Okay, so this is Chapter 3, Hearsay, Direct Admissions, generally. We looked at the case of Salviti, which represents FRE 801D2A, as well as CEC 1220. In the advisory committee, for further description, advisory committee note to FRE 801. Against interest circumstance creates trustworthiness. Referencing or comparing to opinion rule, firsthand knowledge, Edmund Morgan admissions, treatise, no restriction on personal admissions usually applicable to testimonial evidence. See McGee case. McCormick on evidence, section 254, 2013. Treatise. Exception to hearsay if statement made against declarant's interest at time it was made. Exception. Not applicable to admissions. Admissions and multiple hearsay. FRE 805, CEC 1201. See case Reed versus McCord, 1899. See case Foster Commissioner of Internal Revenue. Salzburg, Martin, Capra, FRE manual, treatise. What is not hearsay? Party opponents' statements under 801 and certain prior statements if available witnesses. 801. What is hearsay? 803. 804. 807. 'Subject to exception. 805. Hearsay within hearsay principle. Limit on multiple hearsay is not all or nothing with respect to party opponent statements under 801 D2 and also 803, 804, 807, as I stated above. So these are all treatises that are explaining admissions and multiple hearsay. And before that, it was direct admissions. And 805 is hearsay upon hearsay. Let's forge ahead. Admissions and completeness, FRE 106, CEC 356, Case Beach versus Rainey, adoptive admissions, FRE 801, I'm just giving all the citations at this point, but I don't really have anything. I'll need to get it out of the code. I don't have anything on this. But I gave the completeness doctrine above from my class notes. Admissions by opposing parties. That might be one to highlight. I'm just kind of reversing, going backwards here. Prior statements by a witness, even though, right, well, Might have to look into that too. So let me actually give myself comments to look up. That prior statements by witnesses, I just want to research that. But I think I understand it now that I'm finally seeing the book notes, is that it was one way that it could be, whether or not they're out of court statements or if they require that the statement have been under oath. And it seems like in 1974 or so, we just went back and forth on that issue, which is why it's so confusing. What is it today? And based on like dialogue with the professor, have to be in court under oath, subject to. All right, so we're back in here in adoptive admissions. These are a treatise. Some of these treatises, they take them or leave them. I wrote down what I could make out of it, but a lot of advisory committee note D2B. Example, acquiescing to a co-conspirator's admission in criminal law. Civil, it may be more applicable. Criminal is difficult because attorney may recommend silence. Miranda may be reason to withhold. Authorized admissions, FRE 801. So, yeah, I really didn't know that the Miranda may be reason to withhold. So I'm just kind of highlighting that because I sometimes find it hard to believe that can make it truly define unavailable witness. Anyhow, for authorized admissions, let's continue. Advisory committee note. Admission includes statements to third parties. Admissions include statements from agents to principals. A party's books or records are usable against him. Agent and employee admissions, FRE 801. co-conspirator admissions, FRE 801. Okay. Advisory Committee note to FRE. Apply test of agency. Admissibility limited during the course and in furtherance of the conspiracy. Deny admissibility to statements made after the objectives of the conspiracy have failed or been achieved. Case So under agent and employee admissions, I actually had more to write. So, which is good. It just was out of order on my papers. So, usually not admissible because agent isn't employed for purpose of making damaging statements. Admissible when matter is within scope of agency or employment. So I've already written up the cases for this section. So I'm going to skip through quite a bit. Continuing with treaties in the section of co-conspirator admissions. So, Advisory Committee Note to 1997 Amendment to FRE 801. Revision cares for issues from Borgelli case. Court may consider co-conspirator statement for existence of conspiracy, participation of declarant, defendant. I didn't really know that, so that's why I'm like highlighting that. Okay, let's make it red. I mean, it's not that I didn't know that, it's just that I was confused about that. So, I misunderstood that. Statement above is not sufficient to establish conspiracy and so requires circumstantial evidence. Rule 801D extended. And so that kind of explains why I was confused about it, is because it's not sufficient on its own to establish a conspiracy. So that would have helped a lot in my last essay if I felt certain about that enough to make the professor notice that that's what I was trying to say. Anyway, yeah, it extends 801D to C and 801D to D. And while I've been just saying 801D, C pertains to authorized admissions, and D pertains to agent-employee admissions. So agent, C, and I'll say authorized in parentheses so that you don't have to look it up. Now, further, admissions and the Bruton rule. When a defendant are tried together, a prior statement by one will be admissible against him, but not the other co-defendant. Difficulty when the admission by one is incrimination of the co-defendant, because either hearsay or confrontation clause bar admission and must be resolved by jury instructions, which can be insufficient. Spontaneous and contemporaneous statements. Generally admissible exception to hearsay thought to be reliable, whether or not declarant is an available witness. Elements of contemporaneous are twofold. Rule 803, out-of-court statement made contemporaneously with event that placed declarant under some emotional strain. Lily. Treatise. An introduction to the law of evidence. Re geste is an excited utterance that constitutes a part of the thing done and is consequential as spontaneous explanation that may or may not have been exactly contemporaneous. Exception to hearsay. Hutchins treatise alludes to this based on deposition, horrific accident, 5 people tell stories that can't all be correct. Walt's treatise, the present sense impression, exception to the rule against hearsay, origins and attributes. Examples of different recounts of the same scene. The point is to criticize the feigned reliability of excited utterances. Fiore in New York World editorial describing an accident involving a coachman, 1 death and 5 injuries. State of mind. FRE 803. 1250, 1252, 1260. When an out-of-court statement is used as circumstantial proof of the declarant's state of mind, the hearsay generally is not implicated because the statement is not offered to prove the truth of what it asserts. Rule. Advisory Committee note to FRE. Exception 3, state of mind, is an outgrowth of exception 1 for usefulness and accessibility. The Hillman Doctrine. From 1892 case, extending state of mind exception to statements of intent offered to prove that declarant actually did what they said they would. See page 153. Wherever the bodily or mental feelings of an individual right materially to be proved, the usual expressions of such feelings are original and competent evidence. Brooks treatise. Usual outcome settled with 7 cases for total of $35,700. Proof of doing act intended. The anonymous corpse. Advisory Committee note to FRE. Shepard Holding upholds Hillman. The exclusion of statements of memory or belief to prove the remembered or believed state of mind is necessary to avoid the virtual destruction of the hearsay rule, which would otherwise result from allowing some provable by a hearsay statement to serve as the basis for an inference of the happening of the event which produced the state of mind. Report of the House Judiciary Committee. Hillman limited statement of intent only admitted to render statements of intent by a declarant to prove his future conduct, not the future conduct of others. Injury reports. Statements to physicians for purpose of medical diagnosis are exceptions to hearsay because self-interest breeds honesty, but are inadmissible if for the purpose to litigate, i.e. testimonial. Also, maybe testimonial. Advisory Committee notice to FRE. FRE 804. Okay, so it's not actually 804, it's 803 in parentheses. There's a 4 after that. So what's this advisory committee say about it? Same regarding the testimonial possibility. AD's position is consistent with Rule 703 that facts on which expert testimony is based need not be admissible in evidence if not the kind predominantly rendered by experts in field. So what is the Bruton rule? Let's return to Bruton. The reason why we return to Bruton is because there's a Bruton doctrine we discussed above. Admissions and the Bruton rule. Now here in my notes from the book, it says when a defendant are tried together, a prior statement by one will be admissible against him, but not the other co-defendant. Difficulty when the admission is by one. When the admission by one is incriminate, or one incriminates the other. Because of either hearsay or confrontation clause, which bar admission and must be resolved by jury instructions, which can be insufficient. So, let's see, put Bruton, I guess, let's put Bruton up there where we're talking about it. This is case 43. Bruton versus U.S. Bruton convicted of postal robbery. Admission of co-defendant's confession that implication defendant at joint trial constituted prejudicial error, even though trial court gave clear, concise, and understandable limited instructions that confession could only be used against co-defendant and must be disregarded with respect to defendant.
And no phone.
Admission of co-defendant's confession that implicated defendant at joint trial constituted prejudicial error, even though trial court gave clear, concise, and understandable limited instruction that confession could only be used against co-defendant and must be disregarded with respect to the defendant. Case holding sets precedent, I'll say, as reasoning is a denial of due process to give jury ability to consider one person's admission against him, but not his co-defendant. I'll just say further reasoning. Gray versus Maryland. Ojibwana. Edwards. Elam. Two of these cases I briefed. Harris. Mutual Life versus Hillman. There's that Hillman case. Shepard versus U.S. In fact, let's go through the Hillman case while we're at it. I feel like this is also the anonymous corpse case, but I could be wrong. It probably is. All right, so where's Hillman? Okay. Let's give the case. Case 49. Mutual Life Insurance Co. versus Hillman. I love this case. I love the old cases. Defendant for insurance company not willing to pay widow because they believe husband was alive. That's mutual life insurance. But the plaintiff sues defendant for not being willing to pay widow because they believe the husband is alive. Now, the facts are interesting. I'm going to share them without typing them. Insurance company theory is that Walters left Iowa, writing to sister and fiance early March that his intent was to go to Colorado. So, letter containing intent to go to Colorado was entered into evidence. from that point forward, no further letters were received, and decedent was never heard from again. But body at Hillman's purported at camp purportedly Hillman's discovered this is crazy. Bears resemblance to decedent both Walters and Hillman. The letter was entered as pretext of Walter's intent, not hearsay to prove a fact of the matter asserted. SCOTUS believes letter admissible through research by Howard Professor Justice, making new doctrine. Personal expression of his then present intent is never more competent than his own letter. We will then we'll skip 3 cases. We'll brief Rock versus Husco, People versus Humming, Ward versus State, Fisher versus Swartz, before we get to more book notes. And because of the time involved in case briefing, and because I mess it up so bad when I try to say it out loud, I may be doing that case briefing off the recording. And actually, while I'm recording, I'm just going to finish 2 more pages of book notes. So, recorded recollections. Exception to hearsay rule. If witness forgets her recorded recollections, these can be admissible under modern evidence law. Used to prove the truth of matter asserted, only to allow witness to testify on present recollection. Procedurally, first show opposing counsel and judge. FRE 612, 803, 5, CEC, section 1237. Advisory committee note. Law prefers recency for greater propriety.
Are you talking to me?
California and New Jersey requires that witness not have faculties to testify without recorded recollections evidence. No guidance on contemporaneousness. Multiple party involvement improves reliability. Federal law. Business records. Litigants to prove commercial transactions through carefully maintained records, then by requiring testimony from all employees involved. Reliability, practical necessity vote in favor of this exception. FRE 803 6 7 CEC section 1270 through 72. Generally, advisory committee notes to FRE. Trend to relax witnesses, participants in gathering, transmitting, and recording information to attest to reliability because burdensome on parties. Qualifying businesses. Profession, occupation, or calling of any kind. Report of the House Judicial Committee. Amendment to satisfy foundation with less expense and inconvenience of producing witnesses. Dropped definition. Regularly conducted activity. Amendment. (803)(8) deals with churches, hospitals, and schools. Report of the conference committee. Definition from Model Code Rule 584, 514, 504, Uniform Rule 63, 13, to enter memo with informant details requires informant with knowledge acting in the course of the regularly conducted activity. Advisory Committee Note to FRE 803 6. 6. 6. Rule specifically includes medical diagnosis, prognosis, test results, opinions, acts, events, conditions as proper subjects of admissible entries. Weather reports, accident report, if regular, doctor's report, if regular. What is informant's motive? For litigating, not railroading, as it impacts accuracy, self-serving, not determinative. So that actually comes from a case probably discussed here shortly, where the railroad prepares like incident reports. So I'll call this an example of railroad incident reports because there's actually two cases. Discusses what is informant's motive. Source of the info. Advisory Committee Note. Doesn't limit business records if under duty of accuracy, employer reliance, on-job prep of business record a requirement, i.e. police report is admissible except part incorporated from informant, confidential informant. Accident report doctor's report. Public records. Absence of records. Advisory committee note. Failure of a record to mention a matter which ordinarily be mentioned is satisfactory evidence of its non-existence. FRE 803 FRE 803 8. Narrower than business records. Timeliness of investigation. Special skill or experience of the official. Whether hearing was held and level at which corroborated. Conducted. Confrontation clause if state enters public record in criminal action. Prerequisites for admissibility. Advisory committee note, FRE 803 8. Defined above. Possibility motivation problems. Possible. Agency records ordinarily admitted in case law history. Agencies and sustained on appeal. Evaluate report on 3 factors, 4 or 5 factors above. Formulation approach. Rule 802 supports evaluation report admissibility. that's going to be the last book note in this notebook. So I'm going to end the recording, the YouTube recording now. And I'm going to brief the cases outside this recording.